Good afternoon, everyone, and thank you for joining us for what we hope will be a fun and informative discussion today. This is Tricks and Traps in Leverage Finance. This is episode number 2 of the Financial Poise series titled Leverage Finance. You can read more about Financial Poise on slide 33 of the deck. Our panelists today are Andrew Hutchinson of Mutt Schellist and Joe Patterson of Sidley Austin. And my name is Krista Mancini from Jones Day. You can see our names on slide 6 of the deck and read our bios on slides 26 through 28, but neither Financial Poise nor myself intend for this to be any sort of infomercial, so we will not read those bios aloud. If you want more information about any of us, please feel free to take a look at the slides. A quick note about the slides. I may call your attention to a certain slide as we're going through the discussion, but don't worry if you're listening to this program and not watching. The slides are not critical to the understanding. This is intended to be more of a discussion as opposed to a slideshow presentation. We want to thank our co-producer, the National Law Review. You can read more about the National Law Review on slide 3. Financial Poise webinars are supported in part by sponsors, and the sponsor for today's webinar is Max Asset, and you can read more about Max Asset on slide 4. Last thing before we begin, you'll see slide 5 contains a disclaimer. You are not our clients. We are not your lawyers. What we do here today is just for your general education and not for you to act on without appropriate advice. So without further ado, let's jump into today's discussion. So Joe, given all of the recent focus on liability management transactions and creditors' fears of loopholes within their loan documents, are there certain provisions in loan documents that receive increased attention from creditors nowadays? Perhaps provisions that weren't previously a focal point?
Yeah, thanks, Krista. We certainly are seeing more attention on certain aspects of credit agreements and credit documentations, and specifically around those potential loopholes. The classic examples that we were always focused on were like unrestricted subsidiaries and the J-Crew type protections. But we've seen a kind of a more heightened focus these days and lately on non-loan party assets as well, and also just kind of trying to prohibit certain types of assets such as IP, material contracts, government licenses, assets of those types from being held by non-loan parties at all. We find that like the non-loan party basket size heightened sensitivity is an interesting one because historically, this wasn't as big of an issue because non-loan parties, as long as they're restricted, were still subject to covenants. But when you combine all these different baskets together, it just becomes apparent that there's quite a bit of room for leakage to non-loan parties, and so it's just become such a hot topic for lenders in the market these days. Another place we've seen some changes is around the sacred rights and some additional kind of focus on sacred rights, and especially when you're a minority lender on the right side of a transaction, there's definitely heightened sensitivity around kind of the protections of the sacred rights and essentially subordinating the debt to other creditors, or also just to the benefits of all the collateral. So that's somewhere else that we've seen a lot of heightened sensitivity. One other spot that I think has been an interesting one that we've seen kind of pop up, it's a little less obvious example, relates to like incremental DDTLs. Historically, like our incremental sections, we didn't specifically call out permitting incremental DDTLs. We permitted incremental term loans, incremental revolvers, but not specifically an incremental DDTL. And when we do permit an incremental DDTL, which has become more common, especially in these roll-up type strategies where the sponsor is interested in being able to go acquire additional mom and pop shops and continue to grow their businesses, they want more access and immediate access to these DDTL facilities, and so you're seeing them pop up more commonly in the market, and it just creates these two separate issues that are kind of intertwined, but are definitely just an interesting kind of transition in the market. The first point is just, it's an obvious one of when do you test the incremental occurrence test for a GDTL? The term loan typically gets tested, pulling down the full amount of the loan. So you're going to test it, as it's fully funded. Revolver, we also test as fully funded. But what about a DDTL? If it's a large DDTL and you're not acquiring assets at the same time, how do you fit that into your ratio tests? So a lot of times what we're seeing in these documents is we allow the borrower to test that incurrence test at either the time that they incur the test or at the time that they actually fund the DDTL in the future. This kind of ties to a second point though. Like, so what happens on those if you decide to test the incremental test, ratio test, on the back end when you actually fund the loan? What happens if a sponsor decides to go out and they raise additional DDTL capacity with additional lenders, and they make it to where there's no way that they could ever actually draw on that because the leverage test is just so low that they can never meet that? They're able to actually go out and potentially rig a required lender vote because they could bring in these additional lenders who count towards required lenders, and it creates these issues that you're bringing additional lenders in to maybe get around the existing required lender structure to get something done that would affect the rest of the lender group. So it's something that's kind of keep in mind. So a lot of times, what we've done and we've seen in the market is lenders requesting that for incremental DDTLs, if they want to count them towards direct lender vote, a lot of times that they require them to actually act like the DDTL was fully drawn at the time of incurrence. Alternatively, we also just see, kind of a little looser standard that, as long as it's incurred with a bona fide purpose and not just for the purpose of getting around voting, then you can actually have those lenders count towards required lenders. But it's just kind of an interesting part of the documentation that probably wasn't, thought about too thoroughly in the past. But as, you continue to see these where the liability management transactions are going, lenders trying to, proactively kind of block potential loopholes that could pop up in the documents. Chris, I think you might be on mute if you're.
Thank you. Thank you, Joe. So Andy, what about a creditor who might be buying into an existing credit agreement or acting as, a lender in a large syndicate without much individual control over the negotiation of the credit documents? Maybe they just have to take the paper as it already is. What are some of the key provisions or mechanics in the credit docs that a lender in that sort of a situation should focus on if they want to assess potential leakage risk or layering risk?
Sure. So, I think there are a handful. There are a handful of key items. I think, if I were advising that lender, my first recommendation would be to work with the lender to ensure that, we're covering all of their internal, hot button topics, etc. But just as a general matter, some key items, we would deal with leakage, dilution of collateral, default protections, minority lender protections, and liability management transactions. And those aren't listed by importance. Those are just 5 sort of key topics. So on leakage, what are we referring to? In the documents, like the credit agreement, for example, the negative covenants regarding investments, restricted payments are going to be a key focus. And I won't spend too much time sort of getting into the weeds, but we're looking for things like, are there caps on investments in non-loan party restricted subs? So these are subsidiaries that are subject to the terms and covenants of the loan documents that you're buying into, but they're not providing a guarantor or other credit support. So they're non-loan parties, but they're also restricted pursuant to the terms of the docs. Are there, the investment basket, are there unlimited investment baskets subject to a leverage test? What is that leverage test? Is it closing date leverage? Is deleveraging required? Something inside closing date leverage? That's another important focal point. Restricted payments and restricted debt payments. So this is pure leakage. This is cash leaving your borrower and going to other third parties, not i.e. not going to the lender group. What do those baskets look like? Is there an unlimited RP basket or RDP basket? If yes, what does that look like? Is it subject to any conditions such as no EOD, or is it something a little bit looser? No payment or bankruptcy EOD. Is it also subject to a leverage test? What is the available amount builder basket look like? Does that cover investments, RPs, or RDPs? If yes, is it subject to a leverage test? What is the reclassification provision in the credit agreement provide? Is there a broad reclassification across negative covenants? Does it also include restricted payments and restricted debt payments? So those are sort of the key, again, very high level, but sort of the key leakage items that I would point my client to, and that I would look for in connection with the right side review on behalf of a client that's looking to participate in a syndicated execution. Dilution of collateral. Are there caps on debt incurrences by non-loan party restricted subs? What does the MFN look like in terms of protections? On peri debt. Are there carve outs? Is there an MFN sunset? The default protections, we're always going to really focus on EBITDA. And I'm not going to go through all the add backs, but the classic key focus for most lenders is what is the cost savings synergies add back? Is it capped? Is it uncapped? What's the cap? So that's something that that's going to be a focus of every right side review. The financial covenant, more of an economic point, and that's something that's typically not, that's not going to be a sort of documentation negotiated point. But does it step down? If yes, that's a positive from a lender's perspective. If there are no step downs, or if it's a springing financial covenant, it's going to be a more aggressive doc, or for a different type of structure. Junior lien unsecured debt, are there caps on the incurrence of that type of debt? Is there a no worse than basket or prong for junior lien and unsecured debt? So those are some of the key default protections we would look for. Minority lender protection. So the rec lender definition, we're going to check to see if this next one really only applies in maybe sort of a sponsor arranged club, but not so much in a syndicated execution. But is there a rule of two feature, meaning does the rec lenders provide that at least two unaffiliated lenders are required in order to constitute rec lenders, or is it just a bare majority, meaning 50% or over 50%? We're going to look at the amendments provision very closely. Some of the hot button items that we'll look at in the amendments provision are around sacred rights. Is it sort of what we would expect, which is sacred rights, meaning like the voting provisions, amendments to voting provisions, amendments to the waterfall, pro rata sharing provisions? Do those require 100% lender vote or all affected lender consent, or is it something less than that? And then last, the liability management transactions, which we're going to discuss more, so I won't spend a ton of time on these next couple of points, but we're going to look for, and I won't use the deal names, but we're going to look for whether an amendment or subordination, and this is going to be the amendment section. Subordination of liens requires consent from all directly affected lenders. We're going to look to see if the release provision with respect to release of collateral and guarantees, is it an automatic release? Yes or no? We're going to look to see if there are provisions that provide that transferring material intellectual property to unrestricted subs is prohibited. just blanket prohibited. And we're going to focus on a couple of key aspects under the investment provision that deal with and arose out of the J. Crew transaction. But we'll touch on that in a few minutes. So again, high level, there are other items that we're looking for, but those are sort of like, from my perspective, like really like if you needed to do a 30-minute review, these would be the items I would send you and say, like, let's focus on these and see what's in the doc. And just kind of like focusing on these really sort of critical points.
All right. That sounds like a lot to get through in 30 minutes.
All right, 45 minutes.
Thank you, Andy. Joe, and as Andy has just alluded to, sometimes people refer to the concepts of the J. Crew trapdoor, and we also hear references to black holes and restricted payment black holes. What do these two concepts mean?
Yeah. So, I think first it's kind of helpful to expand on something Andy just talked about as well, kind of this concept of, the restricted non-loan party subsidiaries versus the unrestricted subs. And, typically we have non-loan parties that are still restricted and subject to covenants. Those are, our restricted non-loan party subs. But we also have sometimes these things called unrestricted subs, which are not going to be subject to any of the covenants. When we refer to like the J. Crew trapdoor, we're typically talking about the ability of a borrower to designate like that unrestricted subsidiary and then stack all their different investment baskets, whether it's the general basket, the ratio basket, and any unrestricted subsidiary basket, any of those baskets together, and be able to transfer value out of the credit group to that unrestricted subsidiary. And then unrestricted subs no longer subject to the covenants, which is going to be concerning and alarming to the lender group. These days, we're also seeing similar concerns around non-loan party assets, as I kind of raised at the beginning of this. That's become a much more hot button issue for lenders, because there have been instances where they've been able to move material assets outside to non-loan parties, which can structure subordinate the interest to those assets to the lenders. So it's going to be a concerning issue again for the lenders. So just something to kind of keep in mind. When we talk about like the black hole aspect of this, we're really just talking about the ability to aggregate these different baskets together and use more than one baskets. We're gonna throughout the day talk about different ways that we've seen lenders try to address these and add protections, etc. So I won't go into too many details there, but when you have multiple different baskets, and including, as Andy referenced, ratio baskets that are unlimited, there can be quite a bit of leakage, whether that's through restricted payment, investment, etc., to other non-loan party restricted subs or non-loan party unrestricted subs.
All right, thank you, Joe. So Andy, J. Crew is a big focus when it comes to flexibility of debt terms. We hear that case name thrown out a lot. Can you give us a quick overview of what actually happened in that case?
Sure. So the J. Crew credit agreement transaction, or it's I think just colloquially referred to as J. Crew, was ultimately litigation, but the transaction itself occurred in 2016, 2017. J. Crew at that time, just from a commercial perspective, was facing significant headwinds in the vertical that it operates in, which is retail. Was also facing a sort of looming debt maturity, a couple of years out, and J. Crew and its lawyers looked for ways to create, not necessarily create value, but to de-lever. And the solution they came up with is what we now know as J. Crew. So what does that mean? So under J. Crew's credit agreement, this is its senior secured credit agreement, it used its existing investments baskets to move or contribute about $250 million worth of material intellectual property outside of the ring fence of the credit group, right? So outside of the lender's collateral pool to an unrestricted sub. Well, how do they do that? All right, so there were a couple of investments baskets that J. Crew used initially, and then there was a third prong that allowed J. Crew to move the assets outside of the ring fence. So there was intercompany investments basket of $150 million that J. Crew used to make investments in so we're coming back to this, the non-loan party restricted subs. Again, it's a subsidiary that's restricted pursuant and must abide by the terms and covenants of the credit agreement, but it's not a guarantor. They also were able to use and contribute another $100 million of IP assets to a non-guarantor restricted sub. So now we're at the 250, and that was under just the general investments basket. So 150 under the intercompany investments baskets, 100 million under the general investments baskets were contributed to a non-loan party restricted sub. It happened to be a Cayman Islands sub. It's not really relevant, but it was a non-US non-guarantor restricted sub. The so-called trapdoor, when you hear J. Crew, you often hear the term trapdoor. What does that mean? So is another provision that was at the end of the investments negative covenant. It's basically a basket that permitted investments by non-loan party restricted subs, so the Cayman Islands entity, in unrestricted subs. So an unrestricted sub, as Joe just mentioned, it's a sub that's not subject to any of the terms, conditions, covenants of the credit agreement. It's not providing credit support, and it doesn't need to abide by the covenants of the credit docs. So the Cayman Islands sub contributed the $250 million in IP to, well, I don't even know what it was called, IP Co. This unrestricted sub, we'll call unrestricted sub to make it easier. As long as that underlying investment was financed with the proceeds of other permitted investments. Well, the intercompany investments contribution, the 150, and the general investments contribution of 100, those were both permitted. So that's the trapdoor. So now you've got 250 in material IP that's been moved outside of the lending group's collateral pool. It's now, held by a sub that's that's completely outside of at least pursuant to the four corners of the loan docs, outside the collateral pool that the lenders had agreed to. So I think the purpose from J. Crew's perspective, the purpose of the transaction really was to create and provide J. Crew with leverage so that it could go to its lenders and cut a new deal and delever, etc., which is ultimately what happened. And taking that even further out, I think J. Crew filed for Chapter 11 in 2020, and I don't actually know where that went, but that was the purpose. But the fallout from this transaction was enormous. I mean, I'm sure you both remember. Our lender side clients were very focused on sort of drop down type transactions, and J. Crew was a very hot button topic for several years, for 4 or 5 years. I think now it's just commonplace that for the most part that docs, people are at least looking for it in docs. But this was, it was a relatively recent, I mean, it's been almost 10 years now, so not that recent, but relatively recent transaction where, we're seeing sort of a rise in, these types of sort of transactions. it's something that I think our like lender side clients have become more and more focused on. I'd also caveat all of that by saying, like, if you don't participate in the broadly syndicated market, probably less of a concern. If the credit agreements that you are looking to participate in, or if you're the left lead, if they don't have massive baskets, probably not that much of a concern, or it's certainly less of a concern. But yeah, that's J.Crew in a nutshell. There was significant fallout from this transaction. It was very much in the spotlight for all of our lender side clients for many
I
years.
guess on that topic, Andy, what, assuming the lenders didn't just accept this and did try to fight back a bit on the J.Crew front when they realized what was happening in the baskets and the loopholes that the borrower in
Sure.
that case was trying to take advantage of. Were there any arguments that the lenders or the agent were able to make to stop this from happening, or even if they weren't successful, what kind of arguments might be made?
Yeah, for sure. So J.Crew, wisely, preemptively actually initiated litigation and filed a lawsuit seeking declaratory judgment that what it had done was permitted and was permissible under the loan docs. The bank group, there was quite a bit of litigation around the transaction. The bank group arguing that the transfer itself exceeded, the investment baskets, and sort of the sale baskets or distribution baskets, that it violated covenants under the security agreement, precluding IP from being transferred outside of the collateral package or the ring fence. So there was litigation until the parties ultimately settled. And I think I mentioned, ultimately, like, this was a net positive, I think, for J.Crew, and that they delevered their balance sheet by several, like $300 or $400 million, if I recall correctly. And they were also able to kind of like renegotiate other, I think they had some profit and like some other debt, on terms that were more favorable. But yeah, for sure. And I think in connection with sort of liability management transactions generally, I think litigation is sort of a given, right? Like generally speaking, your bank group is not just gonna go away quietly, particularly for larger deals like this. But
And it's probably safe to assume too that borrowers aren't looking to do these types of transactions and find these loopholes and engage in these actions unless things aren't going particularly great anyway. Do you think that's a fair?
I think that's, yeah, I think that's fair, right? And well, I think we'll, not to spoil it, but I think in some cases it's sort of just like looking for ways to do or to accomplish commercial goals and outcomes that that a borrower's credit docs may not on its face permit. So I'm thinking of like Chewy and the spinoff of, or PetSmart and the spinoff of Chewy, which I don't, but I guess that also I think was sort of really also driven by the fact that like PetSmart was sort of like this legacy business that was not performing as well as Chewy. So how do we, right? So we've got some headwinds there as well. Like, how do we sort of like maximize the value of the the online sale platform separately from the sort of traditional brick and mortar like storefront stuff, which is maybe not as experiencing as much growth, I guess. So, but the short answer is, yeah, I think that's absolutely right. I mean, I think it's, you have borrowers that for whatever reason are maybe it's not necessarily a performance issue, maybe it's an industry issue, but for whatever the reason, are struggling and thinking, maybe we need to look for a creative way to um, um, kind of delever or free up our balance sheet. And I think, if you look at each of these sort of like, um, you know, each of the liability management transactions that you see, like, in the news, even more recent ones, I think they're generally driven by kind of borrowers that are looking for, that really kind of need that extra flexibility, right? If you're sort of hitting all your numbers and, just sort of chugging along, there probably isn't a real, good reason to upset the apple cart and sort of destroy relationships with your bank group over trying to, get cute with a credit agreement.
Right. Yeah, makes sense. Thank you, Andy. So Joe, just briefly, and Andy already touched on it a bit, but what would you say was the market response to J. Crew?
Yeah, I mean, I think the market response initially was just a little surprised. People didn't think that they could do what they did, but obviously, when borrowers are backed in a corner and they find creative solutions, they're gonna, test the limits of what the docs permit. So they've tried to find ways around this. And so, a lot of times what you see are these J. Crew blockers. The J. Crew protections that you typically see prohibits under subsidiaries from owning any material IP. Andy briefly touched on this, but why IP in particular? Well, IP is actually something that's like can be a little bit hard to value, and so you can kind of maybe have more gamesmanship as to what that actual value is going to be when they go to do these transactions, which just allows and just kind of creates more of that flexibility and creativity, which the lenders don't like, obviously. But there's also been a push to thinking about, well, why just IP? If a company has major contracts, or if they have certain government licenses, et cetera, like maybe those assets should also be blocked from being transferred to unrestricted subs, just similar to your J. Crew, your material IP type transactions. I think because the first one was material IP, that seems to still get the most amount of focus. But people are starting to think like, well, let's expand this in certain contexts and when it makes sense. The other things that we're seeing a lot are these Envision type protections. Obviously, Envision's a different transaction, but it's kind of all tied together. Where in Envision the protections, you are typically trying to limit the baskets that can be used to invest in unrestricted subsidiaries. So if you're going to invest in an unrestricted sub, rather than using the trapdoor or any other types of baskets that might be available, you can only use the one unrestricted subsidiary investment basket, which is typically going to be a lot smaller, and also won't have the like unlimited ratio of assets that you have in some other to invest in, even just non-loan parties, or to invest in loan parties. So those are some of the main kind of protections that we're seeing coming to the market.
Got it. All right. So Joe, and Andy mentioned the PetSmart Chewy case. And that was another example of a company using its basket flexibility to the detriment of its lenders. Can you tell us a little bit about what happened in that case?
Yeah, so this is an interesting case. So, PetSmart acquired Chewy back in 2017. They financed it with incremental debt. Both PetSmart and Chewy are household names. You've probably heard of them. COVID hits and Chewy, the online retailer, does really well. PetSmart, the in-store company, was not performing quite as well. And so they were looking for some solutions to delever their balance sheet. So one thing they came up with was to transfer shares of Chewy to an affiliate. So they actually sold Chewy to 16.5% of Chewy to a affiliate. By doing that, Chewy was no longer a wholly owned subsidiary in the loan documents. And because they were no longer a wholly owned subsidiary, there was an automatic release provision that released Chewy from its guarantees and security interest under the loan documents and took that collateral out of the credit group. They did this through kind of a couple steps. There was the transferring first Chewy to an unrestricted subsidiary that they had to create, which is done through the investment baskets, but then they also then dividend that up to the parent. And so that was how they kind of, did through a two-step structure. And by doing all this, that, again, the whole main purpose was that they ended up with Chewy being, no longer part of the credit group, and they're able actually to IPO Chewy, and use those proceeds to go back to the PetSmart to pay off some of its debt. So that was the end of that transaction.
All right, thank you, Joe. So passing it back to Andy, the transfer or release of the main assets of a borrower, a note issuer, can be extremely scary from an investor perspective. Are these types of risks typically disclosed in like the offering memorandum and lender presentations? Do the underwriters and arrangers on these transactions have any sort of duty to disclose these types of things, or are the investors just purely on their own?
Yeah, no, I mean, the short answer is no, right? Like, so, if you're talking about a bond OM or, lender deck or presentation, the materials themselves, right? And the information that's contained within your OMs and your lender deck need to be true and accurate. But they're going to cover things like, the borrower, potential borrowers or issuers performance, financials, its business, specific terms about that, like sort of economic terms about the bond or the loan facility or facilities. But your arrangers don't have a duty to highlight specific risks regarding particularly like documentation risks. That's not something that's going to be covered in those materials. It's not something that that an arranger or an underwriter is going to be have an obligation to disclose around documentation risk. That's kind of buyer beware. I mean, the participants in these transactions, right? Your lenders and or purchasers of bonds are sophisticated institutions that don't need the type of sort of like consumer based protections that just don't if those rules don't generally apply. So it's really kind of, like I said, it's buyer beware, right? The onus, the burden is on your lenders, to review the docs, to do the legwork, to do the diligence, both commercial diligence, the legal diligence, and yeah, that's they're not going to be sort of specific risk factors around up tiering or liability management transactions, etc. It's just not going to be covered in any of that stuff. You're going to need to do that work on your own by reviewing the docs, or having your lawyers do it for you. Each prospective lender or purchaser of bonds should do its own doc review, either internally if you have in-house counsel, or engaging outside counsel to do those reviews, or there are other third-party service providers that do certain types of doc reviews. So like covenant review comes to mind. But yeah, don't expect that your arranger, your underwriter is going to be highlighting really any documentation issues for you, because they have no duty to. It's not something you should ask them for. That's on that's on you.
Got it. Thank you, Andy. So Joe, in the context of these types of transactions that we're talking about, let's assume that the covenants and just the four corners of the document do permit one of these transactions that allows for collateral leakage, obviously, to the detriment of the lenders who are not happy with that result. Is there anything outside of the document that can be done by the lender group to try to stop one of these transactions that arguably is permitted by the actual credit documentation?
Yeah, so I think initially, the question is it permitted by the transactions? But if the lenders don't think it is, you would sue the borrower for breach of contract. And as Andy noted earlier, in these types of transactions and liability management transactions, there's going to be litigation involved. And so typically, you'll have the lenders suing the borrower, or on creditor type transactions, the lenders suing the approving, or the minority lenders suing the approving lenders, saying that they violated their sacred rights. But outside of kind of those direct litigation type strategies, there's also, you could claim fraudulent transfer claims, illegal dividend claims, breach of fiduciary duties by the board. Lenders will also seek, temporary restraining orders, kind of the opposite of, what Annie brought up earlier from the J. Crew case, where J. Crew actually went and sought, the court to actually say that this is permitted. It's kind of the opposite, where the lenders immediately go to the court and say, please put a temporary restraining order on this while we litigate this matter. And then this is also typically when you start seeing lenders form an ad hoc group where they actually will try to, certain lenders, especially, a group of minority lenders, will come together, kind of band together to challenge the transaction, just kind of giving them more leverage in the negotiations or in litigation. This was kind of brought up briefly earlier, but there's different reasons why the borrower might say that they're doing a transaction, but in the J. Crew type transaction, they could say they're moving the assets to the unrestricted subsidiary to in order to borrow money against those assets and provide credit support to the company. That might be like the business rationale, but ultimately the end game in most of these situations is everyone comes back to the table and negotiate kind of go forward plan and go forward flexibility in return for bringing these assets back to the credit group. And so by having an ad hoc group formed early, you're able to then kind of have a little more leverage in those negotiations and kind of protect the lender's interests. So those are all kind of things that the lenders can think about when they might find themselves in a unwelcome situation like a liability management transaction.
And Andy, would you have anything to add on to that in terms of strategies that you might recommend to a lender or investor facing one of those situations?
Yeah, just to piggyback off of Joe a little bit. So that I think coming up with a game plan early on is important. So both as an institution, right? And really just to kind of like, I think doing a full file review, doing a full collateral review, reaching out to not just the transaction, like typically, like I assume your finance attorney, probably outside counsel, probably assisted with closing the deal, but is it time to talk to a litigator, right, or a restructuring lawyer to get their perspective, which may be a little bit different, right, from your transactional finance or leverage finance lawyer's perspective on options. As Joe said, does it make sense to reach out to similarly situated creditors and participate or lead in an ad hoc group of other lenders in connection with exploring options, whether it's litigation or otherwise. Consider depending on the nature of the drop down, consider timing of your perfection analysis. consider timing of, whether to engage a third party to do evaluation analysis of the other business. Those are some of the items I guess I would just add. I mean, I think that these processes, at least my experience, they're not generally resolved quickly. It's, I would say, you're usually looking at, at least a year to, or 1 to 2 years before there's some sort of resolution. And given that time frame, I think like a pragmatic approach that the lender should consider early on is, do I want to go through the expense of trying to, get a better outcome, or does it make more sense economically for me just to sell this paper now? So those are the items I would add.
Understood. Thank you, Andy. Joe, so switching gears a little bit, we just talked a lot about the leakage and drop down transactions in, and then specific examples and the J. Crew space and some other case studies. Similar topic, but slightly different flavor. In workout situations, we also hear folks talk about up-tiering transactions. And another scary word from a lender perspective. Can you give us a few examples and give us a summary of what up-tiering transactions are?
Yeah, so these are the typical creditor on creditor type cases that you hear more and more about. And in up-tiering transactions, what the lenders are trying to do is they're trying to improve their credit position of one class of lenders relative to other classes. So typically, you would amend a credit agreement to issue new, potentially super priority debt to a select group of approving lenders. So the lenders who are approving the transaction, which typically make up at least required lenders, and the debt proceeds there are then used to buy out their existing lower priority debt from just those participating lenders. So this at the end of the day will leave the participating lenders in a better position than the non-participating lenders that are left, now subordinated to those participating lenders. This can come in a variety of different styles. I think we typically think about it in that senior debt to super priority debt scenario where, the one out, certain lenders from the first lien facility will subordinate the minority lenders and put themselves in a better situation. This can be in return for, favorable pricing and just other kind of concessions from the borrowers. They're helping the borrower by providing them more liquidity and also just putting themselves in that better position. So they'll get something in return from the borrower for doing that. This can also come in the form of junior lien debt to just, slightly higher ranking secured debt. So, a second lien could subordinate the minority lenders in the second lien, and they can put themselves as a 1.5 lien or a 1.25 lien, something in between that first lien and the second lien lenders there. So which really eventually just, pushes them down to like a third lien. The minority lenders, that is the third lien. They also could amend the documents to allow additional collateral or guarantees that only benefit those approving lenders and not the other lenders. So it provides them with some additional security and guarantees that in a little more security there. And again, typically the borrower is working with the approving lenders here, so they're going to make sure that they're getting something in return. And then, also just unsecured debt, secured debt, or just structurally senior debt. So you could have a scenario where in a structurally senior debt situation where the debt gets moved to a foreign subsidiary level. So then you're structurally senior to the rest of the credit group above you. And then also subordinated unsecured debt to unsecured debt is kind of another one to where the resulting transaction leads to where the approving lenders are now unsecured without the restrictions that might have come with subordinated debt, and they're kind of now above that subordinated debt level. So those are kind of the different flavors that you'll see.
Okay, got it. So I guess on that same topic, now that we talked a little bit about what up-tiering transactions are to begin with, Joe, are you able to, when we talk about up-tiering transactions, can you give us an example of a case study in the up-tiering space? I think we hear CERTA thrown around as a case study often in the up-tiering transaction space. Can you give us a brief overview of what happened in the CERTA case, maybe?
Yeah, so in the CERTA case, the majority lenders provided 200 million of new first out super priority debt, and they exchanged 1.2 billion of their first lien and second lien loans for approximately 875 million in second out super priority debt. This left the non-participating lenders kind of in the third out tranche. And they were able to structure this to the point where they had their first out at the top, that $200 million, and then their first and second liens, were still sitting above the other non-participating lenders there who got that third out tranche. In this situation, the borrower, only offered this to some, but not all of the 1L and 2L lenders. They did this through an open market purchase. And typically, in a credit agreement, open market purchases are not defined in the credit agreement. This has become kind of a point of contention because just recently, the Fifth Circuit ruled that CERTA's up-tier transaction did not constitute actually an open market purchase, and therefore violated the credit agreement's provisions, because they did not do this on a pro rata treatment of all the lenders. This is kind of an ongoing discussion of what does make that open market purchase, especially kind of in your direct lending type deals where there might not be a traditional open market for those lenders. And so, how do they go about that? So those provisions are ongoingly being kind of amended and tweaked by lenders councils, trying to make sure they're protected for their minority lenders, but also by borrowers council to try to, address the fact that, since open market isn't really defined, how do we get around that and kind of a direct lending deal where there's not a market for it. Ultimately though, they just did it through, up-tiering the debt, issuing new debt, using that money to then, exchange out the lower tiers and putting themselves in kind of a higher position than those non-participating lenders.
Great, thank you. And that's a good point, like you raised there too, that there's even still been recent updates in that line of case law, and like Andy mentioned earlier too, these things can drag on for years and years, some of these case studies. So just because it looks like the court may have found one way, they're on appeal and everything else, it keeps changing, and lenders are following along to see how it plays out in some of the documentation too, and the drafting risks going forward depend on some of those updates in case law. So that's very interesting. So Andy, what can lenders or note holders do to prevent themselves from being up-tiered? I guess similar to the discussion we had for what lenders can do to prevent leakage and drop downs in that space. Similarly, when we're talking about the lender on lender violence in an up-tiering scenario, any tricks or tips for lenders to avoid that type of situation?
Yeah, so I think with respect to the up-tiering, right, the CERTA type of transaction, the single most important recommendation I would make to a lender client is you got to focus on your amendment provision, right, in the credit agreement, and you're looking to see, well, what does it say about subordinating existing lenders, specifically, subordinating or subordination of liens and the capital O obligations under the credit agreement should require the consent from all lenders that are directly and adversely affected. There are some variations on that. We don't need to spend time on sort of going into the weeds, but that's really the heart of it, right? Without that express language, I think you're opening yourself up to getting up tiered, right? Or at least the potential exists. And if you had looked at docs, 8, 9 years, well, maybe not even that long, 7, 8 years ago, 6, 7 years ago, they're all sort of, I mean, they would all be, I think, naked on this point. Or most of them would be. But that's the number one item that I think a lender can do to protect itself. So it's clear drafting, and then specifically looking for certain type protective language in the credit agreement itself. Anti-layering covenants in the credit agreement can be helpful to mitigate against scenario where you've got one class of lenders now sort of in a priming position over another, limiting the ability in the debt docs to conduct drop down transactions just sort of generally. So that would actually go to I think some of the items that we documentation items we discussed earlier around the baskets, stacking, reclassification, the interplay between and the use of sort of intercompany investment baskets, general investment baskets, restricted payments, and your non-guarantor restricted subs and unrestricted subs, and how that all sort of works together can be somewhat of a complex analysis, but really understanding and digging into that, I think, can help on the drop down side. The tight debt baskets, I would add to the tight debt baskets. I mean, I think so. Just sort of thinking out loud and thinking about some of the more recent cases. I mean, we discussed this, I think, last week, and Joe mentioned it. I think like Envision and Pluralsight, where you're seeing sort of different iterations of a J.Crew transaction. I think having, if you're able to get it, right, having sort of a blanket sort of provision that provides that unrestricted subs just can't own or control or hold any material IP, I think solves a lot of these issues. And then I guess secondarily is focusing on sort of what does the credit agreement say around stacking. In other words, like taking your general investments baskets and adding it to the intercompany investment basket, specifically as that relates to unrestricted subs. And maybe the solution is you just have a provision that says, the unrestricted, as Joe mentioned earlier on our call, as unrestricted subs just have one basket, right? And it's a relatively small basket, and maybe that solves it. If there's holdco debt, so if you're dealing with holdco credit facility, ensuring that the debt docs require that the outco remain a direct sub of the holdco. It can't be spun off because you're, as a lender to holdco, right, your credit support's really actually coming from the underlying opco, just generating the revenue. And then maintaining rec lender, sort of maintaining your rec lender group to push back on any changes, including by the use of a lockup agreement, for example, any sort of CERTA type changes. So really kind of like maintaining that collective vote to be able to sort of block anything that comes down the pipeline that is going to negatively impact you as like if you're like a non-pro rata lender, that's a bad place to be. So always helpful if you've got if you have other similarly situated lenders where you can work together and come up with the numbers to be able to successfully vote down or decline to consent to those types of up-tiering potential changes.
All right. Well, thank you, Andy. And I think with that, this concludes our program today. I'd like to thank both Andy and Joe for all of their helpful insights and sharing their expertise. And thanks to all for joining us for today's discussion.
Thanks, Chris.